Yeah, where do I record it though?
What's that?
This will automatically record.
Yes, and then later I'll go and download it and we'll put it on YouTube and stuff.
Okay,
Good.
I think we're good.
Cool. Shoot me a text or call if you have any technical difficulties.
Okay, I will do that.
Awesome.
All right, thanks. Appreciate your help.
Yep.
Okay,
Good luck, John.
thanks. Bye.
Bye.
Good afternoon. I think we're recording here. If somebody could just give me a heads up here, I've tried to change some settings on here. Um, Doing this without Dom has kind of helped me along, but with the construction going on over at our new Diamond office and the old office being uh, taken apart essentially, we're going to try this from the Standale office with um, just little old me today. So I hope this works. Gonna readjust the position of the camera a little bit here. Um, if somebody could just in the comment section put that they're it's looking fine. Hi, it says hi, Ann. Thank you. So Ann's there, and so hopefully we'll have others. Just make sure I know that I can see and hear you. Great, thanks, Ann. Appreciate that. Today we're going to talk a little bit about scope of expertise and whether or not buyer agency contracts are worth the paper they're printed on. And let's start with the scope of expertise. We've gotten a lot of calls lately about areas of real estate that agents seldom come in contact with. And I want to talk about that because one of the rules under the occupational code is that we can only operate within our scope of expertise. We can't, by law and by ethics, go out and start doing stuff that we don't know anything about when it comes to real estate. Now, most of us are trained in showing houses, so that's where most of us make the bulk of our money. Some agents venture into commercial real estate, and there are a lot of other areas that they can go into. For example, property management, ownership of property by stock, the trading in options, right of first refusal, in very manufactured homes is a good one. We get a lot of questions brought to us regarding those areas, those topics, and we have to say we have to be that you have to be very careful about working in those situations when it's not your area of expertise. Now, that said, for example, a lot of agents want to get into commercial. And frankly, I encourage any agent, every agent, to learn every aspect of the business there is because it's always going to help you long term broaden your business. And the more you are diverse in your business, the more likelihood is you're going to survive the hard times. And the hard times are always going to come if you're going to have a long lasting career in real estate. So, if you're going to go into commercial, if you want to learn about commercial, one of the things that you're going to find out about commercial real estate is that most real commercial real estate agents are specialists. They don't learn everything in commercial because it is such a huge uh, area of real estate. For example, I only work on vacant land selection for retail locations. I don't work on buildings. I don't work on leases. I don't work on selling industrial properties. I only work on the site selection for retail, like fast food and banking and so on, because that's what I know. I know what's required. I know what they're looking for in terms of income movement, traffic patterns, egress, and so on. I'm well versed in that one area of commercial real estate, and I rarely venture outside that when I'm in the commercial real estate realm. I may sell a building once in a while, but if you're going to do that as an agent, if you're going to branch out into commercial real estate, I encourage that you get a mentor, someone with a lot of experience in whatever area of commercial real estate you get involved in, and use that person as a mentor and pay them. Give them a 25% referral fee for the first 5 transactions or something that they help you with. Certainly, the broker support team can answer some of those questions, but very often we have to turn to either attorneys or other commercial real estate agents to provide you with the kind of advice that you're going to need. Another area we get a lot of calls on is manufactured homes. Manufactured homes in a park where the unit owner, the manufactured home owner, does not own the property, requires a manufactured homes retailer license. So if you get into a situation where it's a manufactured home in a manufactured home park, we don't have any authority to sell those homes. And that comes as kind of a surprise to some folks. Now, if we have a manufactured home, for example, that's sitting out on a lot somewhere, separate from the house, that the manufactured home owner owns the property, the land that the manufactured home sits on, but it has not been attached in the form of real estate through an affidavit of a fixture and an abandonment of title, it is still considered personal property. That doesn't mean we can't sell the land. We can still sell the land. And it might happen to have the personal property of a manufactured home on it, which gives it value. So again, we're in a situation in that description where we can sell the land. We're actually selling the land, but we're not really selling the manufactured home. We're selling the value of the package, but ultimately it's in the land value. Certainly, we can sell manufactured homes which are affixed to real estate and owned by the homeowner, affixed again in the form of an abandonment of title has been recorded as well as an affidavit of a fixture. So if you run into a manufactured home, one of the things that you need to check on is whether or not it's a manufactured home. Does it have a steel frame under it? Is it been attached? Is there an affidavit of a fixture, abandonment of title, and so on? It's our duty to know what we're selling. Recently, we've run into a few situations where there is ownership of a property by stock. For example, a cabin on a development which is owned by a group of the owners, by the owners themselves, much like a condo, but different in the sense that the ownership is transferred through stock ownership. It's not transferred through a deed. It's transferred through the trade of stock or the purchase of stock. So in those situations, there are a lot of questions that come up. Is there transfer tax required, for example? And what you find if you start digging into it is that if you're only selling, for example, 1/7 of the stock of the property as a whole, the development as a whole, 1/7 being the property that you own and have your cabin on, that does not require that transfer tax be paid. If 50% or more of the property is being transferred, then it is required. So if you're going to deal in those kinds of situations, forgive me, got to see if we can shut this phone off here. If you're going to deal in those situations, know what you're selling. Know from the get-go that you are listing a property or you are selling a property that is not real estate, but actually stock. We get a lot of calls about the right of first refusal. And I want to emphasize here that there's very often the misnomer of the first right of refusal. First right of refusal suggests that there's a second right, and that's not it. The right of first refusal is that the first buyer has secured the right to first refuse, if there's another offer that comes in, to refuse to meet that offer or to remove a contingency, depending on how the right of first refusal is worded, before that seller can accept another offer. Get a lot of calls about prorations calculated by fiscal year and whether it's in advance or arrears. Whether it's in advance or arrears is a really, really big question. It absolutely flips it on its head when you prorate taxes calculated by fiscal year and one county or the buyer or seller perceive that it's been paid in advance, that the taxes have been paid in advance, or that the taxes will be paid in arrears. In one situation, the seller is credited for the taxes that they've already paid, and then the other situation, in arrears, the seller has to credit the buyer an amount for the period of time that they've lived in the property before the taxes came due. So again, if you're not familiar with fiscal year proration and how to calculate it, how to determine whether or not it's perceived as being paid as taxes in advance or arrears, get help. before you get in trouble. Also get a lot of calls on land contracts. Land contracts are, once you get to know them, they're really easy. It's the getting to know them part that's a little difficult. It's important, for example, in a land contract to not only stipulate the down payment and the interest that somebody's going to pay, the monthly payment. You're going to have to run an amortization schedule to determine that, determine if there's going to be a balloon payment, all of those things. But you also have to determine who's going to maintain fire and hazard insurance on the property, who's going to pay for it, who's the beneficiary in the event that the property burns down, for example, or who's going to pay the property taxes, who's the one who's going to write out the check when the taxes come due. If it's not going to be the seller, then the buyer, excuse me, there should be some requirement in the land contract that one of the parties, the party who pays the bill for taxes and insurance, should verify to the other party that those taxes and insurances have been paid. Otherwise, it's possible that that insurance could lapse and the party who has a vested interest in the property isn't covered for any damage that occurs to the property. So when you get into the business of land contracts, either find a mentor or call the deal doctor line. Again, mentoring in this business is really important because very often someone spending time with you who has a lot of experience in it can help you frame the offer in a manner that is beneficial to your client. We get a lot of calls about environmental issues and floodplains and inspections and tax advice, particularly capital gains. What are the ramifications of my seller selling a property? What are the capital gains implications here? We're not CPAs. We're not tax lawyers. We are not attorneys at all. And I have heard us referred to, the broker support team, referred to as our legal folks. I'll call our legal folks. We're not that. We are simply brokers working on behalf of our designated realtor, Paul Carlson, or in some cases, Kim Anderson and so on, depending on the market. But we are working purely as their voice in providing agents advice based on our experience as brokers and active real estate agents. We can't give out legal interpretations of contracts. For example, very often somebody will send us a contract from another market that we're not familiar with, or that they pulled off Rocket Law or something, and they want us to go through that contract and give our legal advice about that contract. That's not within the scope of our expertise. We too have to operate within the scope of our expertise. So when it comes to getting tax advice or setting up a trust, any sort of legal advice and the interpretation of contracts or clauses, we're going to refer you to an attorney to get that information. So I don't know if I have any questions here. I'm going to check real quick and see if we have questions. All right, none yet. So I'm going to jump back to my document here I'm working from. Use the pre-offer addendum. It's really important, particularly in situations where you're working in areas that maybe you're not as familiar with, that you have disclosed and they have acknowledged, the buyer or seller has acknowledged that they have a responsibility to fill out the seller's disclosure form, that they have a responsibility to have inspections done if they've chosen to do them, and so on. If you've never reviewed that pre-offer addendum, please take some time in this week and do it. We have a new one coming, which is even more specific and covers more ground. It's not been loaded up yet, but watch for that. It's going to be, it's really helpful to keep you in compliance and to keep you working within your scope of expertise and not going outside it. The question comes up a lot: how do I enforce my buyer's agency contract? My buyer went off and wrote an offer with somebody else. This is a tough one. It's a very tough one. And the reason it's tough is that you've heard me talk a lot about consequences and the manner in which the contract was presented and whether or not the consequences of that clause or that contract were made clear. For example, in this particular case, when you're trying to enforce, when you have some buyer run off and buy a house from somebody else, we have to go back to the very beginning and say, how was that buyer agency contract presented and how was it described to the buyer? Were consequences made clear to the buyer that if they bought a property from someone else, you would sue them and mean it? Did you add that to the language of the buyer agency contract, for example, to make it abundantly clear that you weren't going to allow them to breach the contract without consequences? Now, first thing you're probably going to say is, well, why isn't it in the buyer agency contract? Why doesn't it specifically state that? And this morning I had to go back and reread the contract, and it doesn't specifically state. There's a clear implication that a buyer agent or buyer broker has the right to sue as a third party beneficiary, but was that buyer agency contract presented and signed, for example, prior to the showing of properties, or was it signed when you wrote an offer? If you signed it in a first meeting and explained it fully, and it was separate and apart of any other documents that you showed them other than the disclosure of agency relationship, that the likelihood of enforcing that contract in the courts is greater than if you simply waited until you wrote an offer and included it with a bunch of other documents for the purchase of a home. So, if you're going to get the buyer's agency contract more enforceable, a couple of options or a couple of suggestions. One is make sure that you fully describe it, including the consequences, and get them to acknowledge that if they breach the contract, you have a right to go after them in court, and show that and have that take place aside from writing an offer. Because if you throw it all in with writing an offer, the courts have a tendency to look at those and go, well, they were just signing a bunch of documents, they didn't know what they were signing. And the courts have tended to lean in the favor of consumers when the buyer agency contractors are signed that way. The other option is that if the other buyer that is the buyer who wrote an offer for your client is under the code of ethics. I'm trying to find the actual practice 16.9, 16-9. Realtors, prior to entering into a representation agreement, have an affirmative obligation to make reasonable efforts to determine the value, whether the prospect is subject to a current valid exclusive agreement to provide the same type of real estate service. So, I'm sure you've all walked into an open house or had the experience yourself of asking the question, are you working, if somebody walks in, you say, first thing, are you working with another realtor? And the answer that you get may or may not be true. That's one of the problems, because if the buyer lies to you and says, no, I'm not working with another agent, and you proceed to write an offer, and then you find out that they actually had a buyer's agency contract with someone, well, what does that mean? It means that that other agent's contract may supersede your procuring cause, or it may not. It's going to be a battle. It's going to be a fight. It's going to be wind up most likely in either a grievance committee or a courtroom to determine who gets paid that commission and what portion of it, unless you happen to be able to negotiate some settlement. I also want, so when you are in the business of getting buyer's agency contracts signed, be sure that you do it before you start showing homes. Don't do it in conjunction with preparing an offer, writing an offer with a whole bunch of forms they all sign at once. And I want to step back just a minute to the issue of working outside our scope. Scope of expertise. Scope of expertise. I see a lot of questions posed on Facebook Connect about what's your recommendation for somebody putting in a septic? What can we say about issues of the neighborhood? If we're asked, for example, is this a safe neighborhood? You know, what are the crime rates? Is there going to be somebody building a development behind, the property and so on? Again, you better have your facts really clear, and they better come from a real bona fide resource if you're going to go into that. For example, if you give a recommendation for someone to do a septic, and they take that recommendation and that contractor botches the job, who are they going to come after? They're not going to come after only that contractor. They're going to come after you as well because you made a recommendation. So be very careful when we're making recommendations. Make sure that you clarify that this is only a recommendation. Even go so far as to get a hold harmless to say, this is information that I'm providing. Take it or leave it, but you can't hold me at harm for any negative outcome here. So be very careful when you're recommending, septic, electrical, roofers, all of those folks that we have to provide information to our buyers or sellers during the process of a house, selling a house, if we need those services performed. When you are commenting on the safety of a neighborhood, you have to make it about crime statistics, and it's best to do something like providing a link to the local police department to determine crime rates. What about a planned development? Do you know before you make the statement, well, see, there's this big woods behind you, behind the property, and so it's nice and quiet and no neighbors? Well, that can change. I once built a house and they made that statement. It was a wooded area owned by a church way on the other side, about a mile away, and there would never be any neighbors behind us. Yeah, within 3 years there was a full subdivision. So that was before we were quite as litigious as we are now as a society. I probably could have gotten some compensation for that, but I chose not to. Um, if you are going to give advice about schools, have provide links that verify that gives the information itself rather than you doing it. For example, if it's a blue ribbon rated school, give the link so that they can look at it and make those kinds of determinations. We have to be very careful about putting ourselves at risk by providing information that is based on opinion rather than fact. And so I think that's pretty much that's a lot of material. Again, buyer's agency contracts are really tough to enforce, particularly if they have no way to if you have no way to prove that the buyer agent who wrote the contract knew that the buyer already had a contract with you. How do you prove that? Well, one of the ways that you can prove it is whether or not, under the disclosure regarding agency relationships, whether they signed it at the bottom that they had or did not have another agency relationship with another real estate agent. Right there is proof whether the buyer lied about it or the agent ignored it. So it buyer agencies are tough to enforce, but if you present them fully and the repercussions for breaking them, for breaching the contract, it can be done, and also to pursue it under the NAR Code of Ethics. So again, I'm going to check one more time before I sign off for questions. Sue. I'm going to have to get Sue. Let me get to the dot loop to see if I can answer your question there. I don't have 5 and 6 right in front of me, so. But stay there. I'll be there shortly. Okay. 5 and 6. Commission paid by others. Okay, let's start with 5. This indicates how you are going to be paid as a buyer broker. For example, a retainer fee is that portion, some amount where they retain your services. For example, when I work on commercial, I require a $5,000 upfront non-refundable retainer fee. Plain and simple, no exceptions. If they don't want to hire me, then I'm not interested in working for them. It's much like an attorney works. Now, that is rarely the case in residential. Under B, if a buyer purchases a property or acquires a same by exchange, buyer shall pay a brokerage fee of some amount. Note that it says the buyer shall pay a brokerage fee and of the price accepted by the seller. The sometimes the brokerage fee will remove the retainer fee, will deduct the retainer fee and pay you the remainder. In other cases, that retainer fee may be completely aside from the brokerage fee if that's your choice. Same thing applies to option fee. If there is an option on the property to buy it, let's say a year from now at such and such a price, and there will be a brokerage fee of, let's say, just for example, 3% of the sales price. That would be under option fee, item C. I suspect that what you're asking in regard to item 6 is what happens when the seller offers a co-brokerage fee, and does that essentially wipe out the buyer's responsibility to pay you? Well, that depends. It says very clearly, buyer acknowledges that brokers representing sellers of property and sellers who sell without broker's assistance commonly offer to compensate brokers who introduce the buyer to the property. It goes on to explain that that amount that you may have up in item 5 will be deducted from whatever the co-brokerage fee is, offset by whatever the co-brokerage fee is. So if you have, for example, 3% listed in paragraph 5, and the co-brokerage is offering, let's say 3%, then the payment to the buyer broker is going to be 3% paid by the seller. That's what paragraph 6 is saying. Now, let's pretend for a moment that you're asking for a 3% commission in paragraph 5, but only 1% is offered through paragraph 6 as a co-brokerage fee. That means that your buyer is still responsible to pay you 2% of the asking price, for example, as a buyer broker fee. So I hope that answers your question. But that's that's basically an explanation of how those two paragraphs work together. And I'm just checking to make sure that we have no other questions. And again, thank you for joining me. I hope that was helpful. And I will see you next week.